कब प्रिंटिंग का ऑर्डर कब एक्सपायर कर रहा है?
May I mention now? You have already called this law, item number 35. This is the first appeal lawsuit addition matter lawsuit. And payout in this case may be
serial number 40.
35.
Issue notice to the respondents. Through speed post. And also already process for which recusals will file within a week.
Call for the records.
Call for the records from the concerned court.
Okay.
Order plenty. Close this case on 24th of September awaiting suggestion.
From supplementary list for final disclosure item 1, first appeal 207 of 1023.
Yesterday I had given substantial dictation of this in my chamber.
Oh.
टाइम हो के नहीं आया, तो इसलिए हम आज रिजर्व भी नहीं करना चाहते हैं क्योंकि आपके सबमिशंस का मैंने डिक्टेशन दिया. ठीक है, तो आई जस्ट वांट टू टेल यू दैट दीज आर द सबमिशंस व्हिच आई हैव रिकॉर्डेड. So I think by tomorrow I will get that dictation. Then I'll let you know and उसके बाद इसको कल कर. उसके बिना नहीं हो पाएगा. Post this case tomorrow.
Orders with defect item 2, first appeal file number 9306 of 1025.
Yes. Which defect you want to be known?
Defect number 25(3). Government card in the certified copy of DT has not been made party in the stand.
Yes.
I was already made party of it. Memo का अपलान नंबर 2 दिलीप कुमार से.
अपील नंबर 1 को क्यों नहीं पार्टी बनाया? नहीं, ये प्लेंटिव नंबर 3 को कहाँ पार्टी बनाया?
ये हमारे मेमो में अपलान नंबर 2.
प्लेंटिव नंबर 3 का क्या नाम?
दिलीप कुमार साहब. ये पेज नंबर 72.
Appellants कितने थे? मतलब plaintiff कितने थे? You are the plaintiff?
Yes.
How many plaintiffs were there?
4 plaintiff.
और 5. ठीक है? तो इसमें 3 ही है, चौथा कहाँ है? नहीं, प्लेंटिव तो शिवनाथ, नवीन कुमार, साहू Dilip Kumar, all sons of 4. Lalita Devi.
Srinath Prasad, Srimati,
ऐसे ये लोग इस तरह से टिकट निकालते हैं। आपका डिटेल्स वगैरह मैच नहीं कर रहा। सिर्फ इतना ही डिफेक्ट थोड़ी है जो आप बोल रहे हैं, डिटेल्स नहीं मैच कर रहा आपका, बाप का नाम नहीं मैच कर रहा होगा या कुछ नहीं मैच कर रहा होगा। 25(3). यहाँ पे डिफेक्ट नंबर 25 है, 25(3) बोल के तो ऐसे रोमन 3. Is this the only defect which is surviving?
25(4).
तो बाकी सब डिफेक्ट आप रिमूव कर दिए हैं. You have filed this IA only for 25(3).
and 4.
25(4). पैराग्राफ 2 आइए का पैराग्राफ
नहीं नहीं, ये डिटेल्स आप किससे मैच करिए ना.
ये डिटेल आपकी previous
Respondent number 5 to 13 in the instant memo of appeal are not party in the CC of the decree. सुनिए, इसका जो डिफेक्ट पॉइंट आउट किए हैं ना, उनको बुलाइए. डिफेक्ट जो पॉइंट आउट किए उनके साथ बैठ जाइए. इतना हम लोग आपके बाप का नाम नहीं कैरी कर सकते हैं बैठ के. ठीक है, ठीक है. अभी आ रहे हैं वो, उनके साथ बैठ जाइए और समझ लीजिए क्या क्या करना है.
Further, Section 3, EP 7 of 2025.
Reducing the file application and order 11 to 12 for production of the documents. Very different to us.
Where is that ID?
That is, yes, application.
Yes, sir. Under order 11 to 12.
तो हमारे हाई कोर्ट रूल्स में तो सारे एप्लीकेशंस को नंबरिंग होता है ना. आइए, कोई आइए नंबर नहीं दिए. नो आइए नंबर हैज बीन गिवन.
ये फाइलिंग
Filing number to the
की रेगुलर पिटीशन.
When did you file it? Yesterday?
on the 11th of August. Day before yesterday.
petition. कहाँ इनका 11th अगस्त का पिटीशन? समीर जी बताइए, कहाँ है इनका 11th अगस्त का पिटीशन?
Application with affidavit.
रिकॉर्ड पे नहीं है. तो ऑफिस वाले क्या कर रहे हैं? इलेक्शन पिटीशन बहुत सारे हैं क्या हमारे? तो फिर उसमें फाइलिंग लिखा अंडर ऑर्डर.
Order 11 to 12.
I have got a copy.
You want to respond to it or you will say?
Well, I will file, definitely I will file affidavit. That reply to the application under order 11 to 12.
Counsel for the petitioner submits that an application under order 11 rule 12 read with section 151 CPC has been filed asking the respondent
9 documents.
furnish 9 documents
Yes,
as mentioned
yes.
in paragraph 7
Yes.
of the interlocutory application.
Yes.
Paragraph 7.
Seven.
Paragraph 7
7 documents. Of the application.
of the application, 7 documents.
Ma'am.
The learned counsel for the respondent placed for 1 week time to file a response to this.
Let it be 2 weeks or not, because we have to search it out or not, whereabouts of the document. They are asking for 2005 and all other documents. If possible, madam. relatives.
Okay, 2 weeks time to file a response to this interlocutory application.
DTO.
If the respondent does not have any objection with filing of one or the other document, the same be produced before this court on the next stage. ठीक है? Post on 27th, ये है क्या petition?
11/8
या इनको वापस करिए और वही petition लगाएंगे.
Permission item for WPL 6.58 of 2025.
ये family. Employees board. You place your case, please.
The petitioner is seeking a refund of 63,100 with interest, which was deposited in the labor code under section 75(2)(b), challenging the order of assessment under section 45(a), which was challenged in labor code under section 75(1)(g). There was, prior to this order, there was an inspection, and on the inspection, the ESI said that you have 21 employees and therefore you are liable for coverage. They made an ad hoc assessment, best judgment assessment under section 45(a), which was challenged by the petitioner's husband, deceased husband, before the EI court. There was a provision, section 75(2)(b), which says that you have to deposit 50% of the amount for entertaining your application. So accordingly, by annexure 5 and 5/1, by 2 challans, the sum of rupees 63,100 total was deposited with the respondent corporation, not in the labor. It was deposited with the ESI corporation. Thereafter, the ESI case was decided against me, which I challenged before this honorable court in appeal. I succeeded in the appeal. On
Who challenged it? Your husband challenged it?
my husband challenged. It is only after the High Court order that the husband died.
It was upheld till the High Court.
Yes, it was.
Where is the High Court's order?
High Court's order is in section 7, page 36. Para 13 is the order. On the question of applicability of the act. Para 13, last line is, therefore the inspection report showing 21 workers employed in the establishment of the appellant cannot be accepted.
That is the threshold.
That was the threshold. So then after that, by series of representations, annexure 8, 9 and 10, the petitioner requested, her husband died after this order. The order came on 17/11/2022. The death was 23/1/2023. So after the judgment, they did not refund. Soon thereafter, within 2 months, the husband died. and after that, this petitioner has been following up, and she gave repeated representations that this money should be refunded as they had succeeded in appeal.
But no response.
So no response. Then, when this writ application was filed, they have filed a counter affidavit. In the counter affidavit, the primary ground is that it was a
Let us see
proprietorship.
the counter.
Yes.
It's a short counter, you just read it.
Para 6, 7, 8.
6, para 6, 7.
That is further stated that an alternative and efficacious statutory remedy of filing an application under section 75 of the Employee State Insurance Act 1948, I have to refer to the act for the sake of brevity, because the Employee State Insurance Code was available to the petitioner, and as such the petitioner ought not to have invoked the jurisdiction of this honorable.
75 is a remedy.
75 1G is any dispute.
So there is no
There is no
dispute.
dispute.
There's a small dispute para 8. Entitlement.
Para 7, that it is further stated that the petitioner is not on the clean hands before this court and on this court alone. Para 8, that it is stated submitted that amount was paid by a distinct and separate legal entity, Messrs. Man in Sales Corporation. The petitioner cannot make any claim for refund in her own name without establishing that she is the owner of Man in Sales Corporation or has succeeded to the said corporation in view of its closure, etc. Now, on this, I am citing a judgment.
Just a moment.
Yes.
It is not in dispute that it was a proprietorship.
It is a proprietorship.
That's
And on that, I am citing it.
yes.
What is the status? 9. That in case no document is forthcoming with respect to closure, etc., the petitioner can only claim refund after obtaining a succession certificate for succeeding the said corporation. Succeeding the said
Except permit would.
That's right.
That is such.
That is all.
Bus limited.
With citation.
Yes. Flag 1.
Flag A.
Yes, flag A. This is 2007 5 SEC 103.
Yes.
Although it arises in an NI Act matter, but the scope of proprietorship has been discussed in paragraph 13.
The distinction between a partnership
The
and a
distinction, paragraph 13.
yes.
The distinction between partnership firm and a proprietary concern is well known. It is evident from Order 30, Rule 1 and Order 30, Rule 10 of the Code of Civil Procedure. The question came up for consideration also before this court in such and such. A partnership firm differs from a proprietary concern owned by an individual. A partnership is governed by the provisions of the Partnership Act 1932. Though a partnership is not a juristic person, Order 30, Rule 1 CPC enables the partners of a partnership firm to sue or to be sued in the name of the firm. A proprietary concern is only the business name in which the proprietor of the business carries on the business. A suit by or against a proprietary concern is by or against the proprietor of the business. In the event of death of the proprietor of a proprietary concern, it is the legal representative of the proprietor who alone can sue or be sued in respect of the dealings of the proprietary business.
That's
Yes. And the second judgment is on unjust enrichment, that it is a tax case which says that state cannot retain any benefit which is not due or any tax which has been incorrectly collected. Para 38. 38 and Paras 38 and 39.
do you really need to cite it?
It is there on an unjust enrichment, and there are two provisions. Regulation which I have quoted in the written argument. Regulation These are ESI central regulations 31A and 31E. Each are on page 3.
Yes.
Regulation.
That's right. It is absolutely equitable.
31A says that if they will recover with 12% interest.
And
31E
if you have to
says
pay,
you have to refer to 31A, which
That's
is again 12% interest. So even the rate of interest is prescribed.
prescribed.
And so far as
That is almost a statutory rate of interest
Yes,
prescribed by law.
yes, and this is not a contribution, this is an assessment,
That's right.
and it was a condition precedent because of which I paid. It was not a payment by mistake
That's right.
that I. This will be.
Right. Yes.
First, if I permitted to first take a look to the data application, I'll come down to the data. In the data application, annexure 2, the statement that they have made is paragraph number 7.
Annexure 2.
Annexure 2. This is the application which they have filed for getting the family heirship certificate. Pilai Sudhakar Praman Patra. No Pilai Sudhakar Praman Patra is all required. This is just an application. It has been received. These are the affidavits. So far as the corporation is concerned, if we are to initiate any process of payment, there has to be some document to certify, to signify that this person is the legal heir of the deceased.
Is she the wife or she's not the wife?
We don't know. As
Have you
there's,
stated that you do not know?
no, there's no report that.
Have you stated in your counter affidavit that you do not know?
Our statement is only paragraph 8 and 9 that until this gives us a session certificate, we cannot proceed further. This is our only statement. Because I cannot make a wrong statement.
Yes.
No,
The payment is to be made not to the legal heirs but to the legal representative.
Lordship, to the legal representative of Manning Sales,
Sorry?
the firm was Manning Sales.
Yes.
The proprietor was the deceased husband. I'm not sure whether, and the petition has been filed by the petitioner and the capacity of the widow of the deceased. So far as the ESI, Lordship, I understand our dilemma. So far as the ESI corporation is concerned, we don't know who has survived the Manning Sales Corporation.
That's right.
Whether the Manning Sales Corporation has been taken over, has been converted by some other proprietor or not. There can be a change of name even. The proprietorship can be changed even. But many a times we have seen that the proprietorship firm, the legal heirs, one of the legal heirs changed name. We adopt the same name and continue with the proprietorship firm, taking the same benefits. So far the ESI corporation firm, we don't have any document to admit her entitlement person. This is the first aspect. The second is not the amount. Now, whether this was a voluntary deposit or a personal deposit, this is the main distinction. Lordship may take up two provisions, Regulation 31E and Regulation 40. I put Regulation 40 in my written notes. First, Lordship may take up Regulation 31 capital E. Now, this 31 capital E is only with regard to 45 double A. And this deposit is not in terms of 45 double A.
31 capital E.
Sorry, 31 small A, I'm sorry.
No, what are you referring? What have you quoted?
No, I quoted
I'm not
Regulation-
able to get where are you taking me to?
He referred to 31E.
Yes.
I'm taking Lordship to that.
31 capital E. Yes. Interest on amount refunded to the employer.
If an employer finally succeeds in the appeal under section 45 AA.
That's right.
So this is limited to an appeal under section 45 AA. There is no appeal under section 45 AA. The,
Appeal is under section?
this is 75. They are in both your resolution under 75.
Okay.
45A order, 45 AA and appeal. So this 31 capital E pertains to refund with the interest on the refund in which the amount is reported pursuant to 45 AA. So Lordship may appreciate under both under 45 AA and under 75. There is a statutory for it.
45 AA is
25 ESI Act appeal to the appellate authority in which 25% amount is to be deposited
No. You see, the original application which they had filed was under the provisions of section 75. It is an appeal or
No,
it
it
is
is an original application.
original application.
Original application
So
before the
against the original application's
appeal lies
application,
before the 82 before the Honorable High Court.
appeal lies before the High Court.
Honorable High Court under section 82 on the point of substantial question.
That's right. So
45AA is an internal appellate, just like departmental appeal.
okay, it is just like a departmental.
So 31E is one aspect. And Lordship, now I have quoted Regulation 40. If I am permitted to take a Lordship to that. Refund of contribution erroneously paid. And why I am saying this is erroneously paid, Lordship may first refer to 75(2) capital B. This I have also quoted. 75(2) capital B. This is the how the amount is to be deposited. Has the Lordship got that? No matter which is in dispute between the principal employer and the corporation inspector of contribution so and so, unless
as in
I'm sorry,
when you are reading a statute, you please read the statute properly.
No matter which is in dispute between the principal employer and the corporation inspector of any contribution or any other dues shall be raised by the principal employer in the EI code unless he has deposited with the court. Return with the court 50% of the amount due from him as claimed by the corporation. So 50% of the amount claimed by the corporation and deposit has to be made with the court. What? As per Annexure 5, they have deposited the amount before the corporation, not before the court. Now, Regulation 40. Lordship may kindly turn to Regulation 40 now. I have quoted that. 41. Refund of contribution erroneously paid. Any contribution paid by a person under the erroneous belief that the contributions were payable by that person in the act may be refunded without interest by the corporation. So there was no mandate for the petition for the concerned firm to deposit the amount with the corporation. They opted to deposit it. So this is a voluntary deposit which can be considered as erroneously paid. And 31 capital E is with regard to interest on the amount that they deposit before the corporation in terms of 45AA. So my submission is interest is not payable if at all. And Lordship, the remaining are as.
What would have happened had their petition been rejected? What would have happened to the deposited amount if their application was rejected?
Then we would have used that contribution.
How?
contribution
नहीं
because
जो डिपॉजिट इन्होंने 50%
in the
कोर्ट
form
में
of
करते
contribution.
जस्ट अ मोमेंट तो क्या करते हैं
What's the refund? They would have taken the refund.
नहीं आई एम नॉट आस्किंग फॉर द रिफंड फ्रॉम द कोर्ट
They,
आई एम आस्किंग यू हैड दे लॉस्ट बिफोर द कोर्ट then what would have you done?
I would have initiated process of recovery.
Yes.
Recovery. These are separate proceedings. I would have initiated process
And
of recovery.
what you would not have touched that 50% amount.
We would have asked the court to hand over the amount.
Okay.
Otherwise, in number of cases, what we do is we do not proceed with the court. We ask the employer to deposit the amount.
What you do is immaterial. What is there under the provision?
The act is silent.
No,
To whom the statutory amount will be paid. The act is silent. Let me be
What
very
do you
clear.
mean? If they lose, the money has to go to
The
you.
money has to come.
Therefore,
And
if they deprive, if they have deposited 50% of the amount, so you will be claiming interest on the entire dues, or you will claim interest only on the 50%.
Just to answer that, I'll give a prologue to the motor vehicle act cases which we do. In that case, also there is a statute deposit of 25,000. This is to be deposited in the court of law. We submit the demand draft before the court of law by way of demand draft. The amount, if at all if the insurance company wins, we just get back the 25,000 amount. If the insurance company loses, the amount is directly paid to the claimant and the claimant claims interest on the entire amount.
No, we are not on motor vehicles.
I'm just going ahead.
Please, please, no. There is no
I'm
question
just
of
going
any
ahead.
analogy because the provisions are absolutely different.
Definitely.
My question is very clear. they have deposited 50% of the
My
amount.
lords.
Like if 100 rupees was the due, they have deposited 50
50
rupees.
So we term it as a voluntary deposit.
आप बोलते बहुत हैं, आप क्वेश्चन
Answer.
बिना समझे मत
Answer.
बोलिए,
My lords.
ठीक है?
My lords.
2001 का ड्यूज है, 2002 में इन्होंने डिपॉजिट कर दिया 50%.
Definitely, my lords.
The case is decided in 2010.
My lords.
While recovering the amount, if they have lost the case, will you claim interest for the entire 100 rupees right from 2001 till 2010?
We cannot.
You cannot.
We cannot.
तो आप कितना इंटरेस्ट क्लेम करेंगे? On which amount will you claim the interest?
The balance amount which has not been deposited to us.
No,
But if I just add
the
on.
balance
But
amount,
if-
no.
but
No
if-
amount is deposited to you
Then
because the act does not prescribe any deposit to you.
If the amount
But
is
so
not
far as
deposited
that
to us.
50% amount which has been deposited in the court is concerned, they will not be saddled with any liability to pay interest on that,
If
or they will have to pay interest on
Madam,
that.
if we see the regulation 31A, interest on contribution due but not paid in time, as per this contribution has not been paid to us in time. As
So?
per us, it is not. So we will be claiming interest on the entire amount.
On the entire amount, including that 50% which was deposited in the court.
Definitely, we should.
I do not know.
But
What you do, I am asking you, what is the provision of law?
The provision is 31 capital A. An employer who fails to pay the contribution within the period specified in Resolution 31 shall be liable to pay simple interest at the rate of 12% per annum in respect of each day of default or delay in payment of the contribution. This is the resolution. So, by virtue of contribution, we mean contribution which is paid to us. The 2B, if you also permit me, 2B is the contribution which is deposited in the court. So now so far this amount is concerned, we consider it to be a voluntary
Why
deposit.
did you take it?
They deposited, we did not. It's a challan.
So therefore,
It's a challan. They are free to deposit.
right, they are free to deposit. Then the application itself was not maintainable. Then the application itself should have been dismissed on account of non-deposit,
This
isn't it?
because it as per them,
Application should have been dismissed on account of non-deposit.
definitely matters.
Simple.
But it did not happen. This aspect for any reasons because 2B as we mentioned, the amount has to be put in court. They filed a waiver application, the waiver application was dismissed.
So the amount which was deposited with you, maybe by the mistake of both the parties,
Definitely.
was accepted as the amount deposited in
Definitely.
terms of the provision of the act. But the fact remains that you enjoyed that money, isn't it?
We as a corporation do not enjoy any amount for the reason we send it to the centralized pool. From there, the social security.
Enjoyed means what? Utilized. आपको थोड़ी आपको making मेरी करने के लिए आप film देखते चलेंगे. Enjoyed means that the money was with you and you have utilized it in whatever manner, whether it was lying in your bank account, you were earning interest on that, or it was utilized for any purpose.
That's why this regulation has two aspects. One is regard to voluntary deposit, one is regard to 45A deposit.
You see, now this particular deposit, which has been taken as a statutory deposit, right, without any objection from your end, right, you have not taken it as a voluntary deposit. You have taken it as a statutory deposit, and instead of deposit in the court, it was deposited. And you have availed this.
Because Regulation 40 caters to that. Any deposit is voluntary in nature.
What do you mean? You cannot treat it as a voluntary deposit because it is a statutory deposit.
They opted to file an application. They opted to have it waived. It was declined.
That's
so
right.
Thereafter, they could have reported before the court.
They could have.
You
see, they deposited 50% before you, right? You could have said that this 50% deposit has nothing to do with the matter. Now they are supposed to deposit the 50% amount in the court.
The argument which I am trying to make is, the waiver was declined. They were duty bound to deposit before the court as a statutory deposit. They did not do so. They deposited with us. So any amount that they have deposited with us would be a voluntary deposit because this is not a 45AA deposit.
But it was taken as a statutory deposit.
You
also took it as a statutory deposit. You never objected to the objection.
There is no acknowledgement from my end that this is statutory deposit.
It is your conduct is enough.
In practical sense, what happened? I'll just tell the practical sense. in the code before we also many times we say that we deposit with the corporation, the amount is deposited with the corporation, so that the future interest is waived. The future interest on that amount is stopped. Otherwise, we'll be claiming interest on the entire amount. So the entire purpose of this is a calculator. This is taken by the employer concerned, that if you deposit with the corporation, the future interest on that aspect is nullified. Over here, they took a calculator to this. This was a voluntary deposit so far as we are concerned, because there was no coercive measures. There's nothing on record to say that there was any coercive measure. And in terms of that coercive measure, they have defaulted the amount. 31 capital E is with regard to 4588 proceedings. And admittedly, this is not a 4588 proceeding. And unjust enrichment will not apply over here, because unjust enrichment, this is not a taxing statute, this is a contribution.
Unjust enrichment will not apply, but you are unjustly enriched. There is no doubt on that.
I am not, this is not the case that I am taking his money, earning a profit and doing some works.
That is
No,
exactly.
it is not, we don't earn profit out of it. It is his money, the contribution is used for the social security measures.
It is immaterial whether you earn profit out of it or you throw it into the well.
By that
They
logic,
are
what
deprived.
They
They are deprived for your illegal acts.
They
They are deprived for your illegal acts because they have been wrongly put for a liability which never existed. This is the factual situation now.
Ultimate conclusion is, but the EI court acknowledged and admitted that yes, they were duly covered.
So that order does not exist.
The EI court
It was a wrong order.
Definitely, but it acknowledged at that particular point of time. It acknowledged. So the judgment, so neither party can be allowed to benefit. This is the in a nutshell. This is the case.
Now you listen to the order. Right? Heard the learned counsels appearing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the firm, namely Messrs. Mann in Sales Corporation Ranchi, was the proprietorship firm of the husband of the petitioner, namely Anil Kumar Sood. Pursuant to an order passed by the respondent authorities, the firm was said to be covered under the Employees State Insurance Act 1948, within bracket, hereinafter called the ESI Act. By holding that there were 21 or more employees in the firm. An application under section 75 within bracket 1 within bracket G of the ESI Act was filed before the learned presiding officer, Labour Court cum Employees Insurance Court Ranchi, which was numbered as ESI case number 2 of 2004. And in terms of section
75 to B, capital B.
75 to within bracket B, for Bombay, capital B. which requires 50% of the deposit in the court of the amount in the court. The same was deposited by way of challan before the respondents. The challan has been placed on record. The learned counsel submits that the case was dismissed by the concerned court by judgment dated 28th of April 2009, which was challenged before this court in MA number 160 of 2009, and the appeal was allowed, and the order and the appeal was allowed by holding that the inspection report showing 21 workers employed in the establishment of the proprietorship firm could not be accepted. The learned counsel submits that after having won before this court, the proprietorship, the proprietor, who was the husband of the petitioner, filed his application for refund of the amount, 50% amount with interest, and the 50% amount so deposited was rupees 63,100, and he claimed interest at the rate of 12% per annum from the date of deposit till the date of refund. Yes, from the date of deposit till Lalit Kishore Sood. When did he die?
21 and the date dated, that is 2/1. So we have also made a statement as
The wife made the application.
Okay. The wife of the present petitioner made the application for refund with interest at the rate of 12% per annum. The husband of the petitioner expired on 23/1/2023. The learned counsel submits that in spite of repeated representations, when the refund was not made, the petitioner had no option but to file a writ petition seeking refund. The learned counsel appearing on behalf of the petitioner by placing the case has submitted that the petitioner, being the legal representative of the proprietor of the firm, is entitled to seek refund, and the objection raised through counter affidavit is not sustainable in law. The learned counsel submits that as per the section 75 within bracket 2-B of the Act of 1948, no matter in dispute between the principal employer and corporation shall be raised before the ESI court unless the employer has first deposited 50% of the amount claimed, and the court is empowered for reason recorded to waive or reduce that deposit. The husband of the petitioner had filed an application seeking waiver, which was rejected on 1/3/2006, and consequently, the sum of rupees 63,100 was deposited before the respondents. The learned counsel has submitted that there is a statutory provision for refund, and for that purpose, he has referred to section 31 capital A of regulation 31 capital A of Employee State Insurance within bracket general bracket close regulations 1950, and has submitted that
1E regulation.
31A, no?
31E is the refund for the employer, and A is the interest portion, so it refers to 31A.
Okay.
The same rate at which
That's
they
it.
would.
He has referred to section to regulation 31A, which is in turn relating to interest on contribution due but not paid in time. He has then referred to regulation 31E to submit that a provision has been made on the amount which is for payment of interest, which is refunded to the employer
If he succeeds.
if he finally succeeds in the appeal under section 45-AA. And the rate of interest is the same as provided under regulation 31A, that is 12% per annum. The learned counsel has further submitted that the petitioner has also placed on record the calculation made at the rate of 12%, has also furnished the following calculation and has submitted that total amount due and payable as on 13/8/2026 is 2,13,440.50. This calculation has been produced before this court along with the written submissions filed by the counsel for the petitioner. The learned counsel submits that the learned counsel has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2007 bracket close 5 SCC 103 Raghu Lakshmi Narayanan versus Fine Tubes, and has referred to paragraph 13 thereof to submit that in paragraph 13 of the same judgment, another judgment of the Honorable Supreme Court passed in the case of Ashoka Transport Agency versus Avdesh Kumar has been referred, which is reported in bracket 1998 bracket close 5 SCC 567, and has submitted that it has been held that a proprietorship concern is only the business name in which the proprietor of the business carry on his business. A suit by or against a proprietorship concern is by and against the proprietor of the business, and in the event of the death of the proprietor of a proprietorship concern, it is the legal representatives of the proprietor who alone can sue or be sued in respect of dealings with the proprietorship business. The Learned Counsel submits that paragraph 13 of the aforesaid judgment is quoted as under. The Learned Counsel has further submitted that there is no distinction between a proprietor and a proprietorship firm, and it is only the business name of the proprietor concerned. Upon death of the proprietor, the petitioner, being the widow, is the legal representative of the proprietor and is entitled to seek it. The Learned Counsel, that is all. The Learned Counsel has also submitted that denying to give refund, much less refund with interest, to the petitioner through the counter affidavit amounts to unjust enrichment of the respondents who have enjoyed the money deposited by the petitioner, which was a mandatory deposit in terms of the provisions of that. That is all. The
Only
Learned
one
Counsel.
small clarification. 45AA and 75(1)G both are parallel remedies. I can challenge either under 45AA or 75(1)G. So therefore, we are saying it is pari materia provisions.
The Learned Counsel has also submitted that section 45 AA and section
75(1)G
75(1)G
both are parallel.
both are parallel
71G
remedies.
is larger.
Both are parallel remedies which were available to the petitioner to challenge the action of the respondents. However, the proprietor of the petitioner, however, the husband of the petitioner had invoked section 75 within bracket 1 within bracket G of the Act of 1948. The Learned Counsel for the respondents, while opposing the prayer for refund, has submitted that the writ petition itself is not maintainable, as the petitioner has an efficacious remedy in the form of appeal.
Application, original application.
You have mentioned in the form of appeal.
Application 6. Filing an application.
Para 4.
Answer, para 6 would be. Para 6.
Has in the form of an application which is to be filed under section 75 of the Act of 1948. He has further submitted that the petitioner cannot claim any refund in her own name, as the proprietorship firm is a separate legal entity, and she has to first establish that she is the owner of the proprietorship firm or has succeeded to the said firm in view of its closure. Further, an objection has been raised that the petitioner can claim refund after obtaining a succession certificate for succeeding the firm The Learned Counsel has also submitted that the petitioner, through Annexure 2, has only made an application before the circle officer for the purposes of issuance of the family certificate, but no such family certificate has been placed on record. However, in the writ petition, the affidavits of the sons of the petitioner has been placed on record. After hearing, that is all.
Regulation 40 and 2B, it was not reported, report was reported before us.
The learned counsel for the respondent has submitted that, has referred to section 75 within bracket 2 capital B. And has submitted that the amount of 50% was required to be deposited in the court and not before the respondent. And the petitioner and the proprietor and the husband of the petitioner being the proprietor of the firm having deposited the amount with the respondent, such amount is to be considered as a deposit of contribution in terms of regulation 40, and at best the proprietor could have been entitled for refund of such amount, but such refund would be available without any interest.
And 31 capital E talks about interest on a appeal which on succeeding in the appeal under
Yes,
section
the
45.
learned counsel has further submitted that regulation 31 capital E refers to interest on the amount which is refunded to the employer if he finally succeeds in the appeal filed under section 45 capital AA, and the same does not refer to
75 proceedings.
section, the proceedings under section 75.
Just one small thing, but I should note it. Para 16 counter में इनका एक डॉक्यूमेंट लगा दिया, there may be a typing mistake on his end. ये डेट ऑफ डेथ ऑफ द हस्बैंड इज 23/1/2023, उनके एप्लीकेशन ये लगाए गए हैं पैरा 14 और 15 में 2/1/2023 का प्रायर टू द डेट ऑफ डेथ.
No, but she herself is.
But prior to the date of death, she would not have.
That's right, but subsequently she has filed it.
The death certificate is not.
नहीं इनका एप्लीकेशन दिखा रहे हैं, हम बस बोल रहे हैं इनका एप्लीकेशन दिखा रहे हैं.
That's right, it is 2/3/23.
2/1.
2/1/23.
And the date of death is 23/1, so she would not have filed an application prior to the date of death.
The learned counsel has also submitted that the petitioner being the wife, claiming herself to be the wife of the original proprietor, had filed the application for refund on 2/1/2023, which is prior to the death of the proprietor, who died on 23/1/2023.
In this, she is not mentioning that my husband has died.
Yes.
She's signing because
Yes,
he may
yes.
have been on deathbed.
That's right.
He died within 2 months of
That's
the
right.
order.
That's
Within 2 months he died. He may have been on deathbed.
not within 2 months.
Within
but
2 months
within
of the
20
high court
days.
order.
20 days, within
Some
20
days,
days.
within
20 days.
11 and then.
Yes. In response, the learned counsel for the petitioner has submitted that the application seeking refund was filed by the petitioner, but she did not say that her husband has expired. The husband expired within 20 days from the filing of the application, and there could be compelling circumstances under which the petitioner, being the wife of the proprietor, had filed the application. The date of death as per the death certificate is 23/1/2023. After hearing the learned counsel for the parties, this court finds that the petitioner, aged 77 years, who is the wife of Anil Kumar Sood, who was the proprietor of the firm, namely
Man in sales.
namely Messrs. Man in Sales Corporation, Ranchi, has filed the present writ petition, placing the death certificate of her husband on record at Annexure 1. The details of the place where the husband died and the address of the petitioner also happens to be the same. It is further not in dispute that the application under section 71 with method 1D was filed by the husband of the petitioner, challenging the order of the respondents by which they were alleged to be covered under the Act of 1948, and the application seeking waiver was dismissed. It is further not in dispute that the amount of 50%, that is amounting to rupees 63,001,
100.
that 63,100 was deposited by before the respondent by Chalan, and the respondent have enjoyed the money throughout without any objection, although as per the provision of the Act, the amount was to be deposited in the court. However, no objection was raised with respect to the manner of deposit, and the case was ultimately decided. The application was dismissed with the subject matter of appeal in MA number 160 of 2009, and the coverage was set aside, meaning thereby the firm was out of the purview of the ESI Act. And consequently, the firm had no liability at all towards the respondents. The application seeking refund was filed, and it was followed by a number of representations, but no response was forthcoming from the respondents, and consequently this petition was filed. The respondents have made an objection that in absence of any succession certificate, the refund may not be allowed in favor of the petitioner. Apart from that, they have also made an objection that the amount which has been deposited with the respondents should be taken as voluntary deposit, and after the order of the High Court, the legal legal representative of the deceased proprietor could be entitled to refund of the said amount, but there is no question of payment of any interest. So far as the objection with respect to refund without any succession certificate is concerned, no dispute has been raised by the respondents in their counter affidavit that the petitioner is not the wife of the deceased proprietor of the firm. Further, the records of the case also reveal that the other details of the proprietor of the firm and the petitioner are matching upon comparison with the death certificate and the details furnished by the petitioner in the petition.
I've also produced the challans that also I have given to
The challans have been produced
copies, photocopies.
by the petitioner, which reveals that the challans and other connected documents have been produced by the petitioner in the petition, which reveals that they are otherwise in possession of the required documents. In such circumstances, this court is of the view that the objection raised by the respondents regarding the locus of the petitioner to file an application seeking refund is misplaced, and at best, the respondents, by giving refund if it is found payable to the petitioner, they can seek an indemnity bond from the petitioner, subject to any objection that may be raised in future.
Indemnity bond, subject to objection छोड़ देते हैं.
Okay, indemnity bond.
Indemnity bond कर रही है.
Okay, that should be sufficient.
Subject to
That
objection
will,
बहुत हो जाएगा.
this modality would save the interest of the petitioner as well as the respondents. The petitioner at the time of filing the petition was already 77 years of age. So far as the entitlement of refund is concerned, the same otherwise cannot be disputed, inasmuch as, in view of the judgment passed by the Honorable Supreme Court, the proprietorship firm and the proprietor are one and the same person, and it is the proprietor only runs the business in the name of proprietorship firm. The existence or non-existence of proprietorship firm is of no consequence, as till the date of filing the petition, no liability has been crystallized in favor of the proprietorship firm, and it is not in dispute that the proprietorship firm was not covered under the ESI Act.
Proprietorship firm is not covered.
Was not covered under the ESI Act,
For the meaning.
and therefore the respondents were not entitled to claim any money from the proprietorship firm. So far as the objection in connection with payment of interest is concerned, this court finds that although the statute prescribes that the amount was required to be deposited in the court, but in the peculiar facts of this case, the amounts were deposited with the respondents, and such deposit was undisputedly made in view of the fact that the application seeking waiver of deposit was rejected and the same was deposited through challan. It is not the case of the respondents that the deposit made through challan was not deposit in terms of section 75B 2B of the Act,
Yes.
of the ESI Act. In view of the aforesaid facts and circumstances, this court finds that the money of to the extent of rupees 63,100, though not deposited in the court, but was deposited with the respondents, and the respondents have enjoyed the money which the respondents were otherwise not entitled under law. Considering these, this court is of the view that the argument of the respondents that such deposit is to be taken as suo motu deposit by the proprietor of the proprietorship firm against the liability cannot be accepted in view of the aforesaid peculiar facts of this case. Since the sorry,
he should have जो चालान है that is deposited under protest.
okay. The challan also reveals that the amount has been deposited under protest, and by referring to the orders passed by the court. Reference of the court is also mentioned. Reference of the court is also mentioned, and it was deposited under protest. Since the respondents have enjoyed the money, this court is of the view that enjoyed the money which they were not entitled.
They just enjoyed the money, but because
enjoyed the money.
they have kept the money.
Enjoyed the money.
Enjoyment would be
have been utilizing the money.
Utilized. Enjoyed would be a negative aspect.
ऐसा कुछ negative नहीं होता है. Enjoyed ही रहने दो.
Lordship may just reconsider that.
I'll take care of it.
Definitely.
I'll find out a suitable word for that.
क्योंकि थोड़ा सा बहुत सा मैटर्स में ये टर्म हम लोग हिट करेगा.
नहीं ऐसा कुछ नहीं कर. देखिए आपको बहुत बचा दिए हैं because the money was directly deposited. I'm not deciding court में deposit होने से refund में interest मिलेगा कि नहीं मिलेगा. I'm just deciding that the amount has been deposited to you. Therefore, he is entitled to interest.
हम लोग अभी बस यही genuine व्यवस्था we could not have so much transferred without
That's
their
right.
agreed document.
In such circumstances, this court वो तो हम उसको reject ही करें. In such circumstances, this court is of the view that the petitioner is entitled for refund of the amount with 12% interest as claimed. The computation as put forth by the petitioner in the written submissions is with respect to calculation is as under. The respondents are directed to verify the calculation, and if the same is found to be correct, or if there is any objection to this to the amount, the admissible amount should be remitted to the bank account of the petitioner within a period of 15 days from the date of receipt of this order.
बैंक अकाउंट ऑर्डर में आ जाए तो
हाँ, आप दे दीजिए बैंक अकाउंट
ऑर्डर में आ जाए तो अच्छा रहेगा
आ जाएगा. In case this order is not complied, the interest would be at the rate of 18%.
comply हो जाएगा take instructions we just need an order our dilemma is because there is no succession there is no family circuit we cannot if it's for 15 days or 21 days it will become
अच्छा ठीक है 21 days. If the amount is not
interest हो जाएगा penal interest हो जाएगा but it will be done
ठीक. I'll remember this.
Definitely.
Content पे नहीं आना चाहिए.
नहीं बिल्कुल नहीं आएगा I assure that
ठीक है. Subject to furnishing of
indemnity bond.
indemnity.
So 21 days will be counted from the date of indemnity bond.
They will come. They'll furnish the indemnity. You'll furnish the indemnity bond.
So it should be counted from that date.
Certainly.
In fact, interest should also be counted till the date of actual payment.
Certainly, the interest should be calculated till the date of actual payment.
Let them give a fresh calculation.
ना fresh calculation आप करिए ना.
Definitely.
इतनी बूढ़ी लेडी से calculation करवाएंगे पर. ये तो नहीं होगा.
When they will pay.
The petitioner shall produce a copy of this order. Simply आप indemnity bond furnish कर दीजिए. Copy of this order along with indemnity bond. Before the authority. Respondent number कौन होगा? Who has to take the decision? पटना थोड़ी चले जाएंगे.
यहाँ पे है. नाम में.
To the respondent number 1, आप director लिखे हैं, regional director नहीं लिखे हैं.
Regional director.
Okay, the learned counsel for the respondent has submitted that the petitioner should furnish the indemnity bond along with a copy of this order to the regional director, Employees State Insurance Corporation, Regional Office Ranchi, Panchdeep Bhavan, ESI Corporation, POPS Nampum, Ranchi.
Patna इसलिए हुआ because at that time they even made my client run because that time there was no Ranchi office. So say that
That's right.
your challan may be in Patna, you go and trace in Patna.
That's right. It's okay.
So but now since there is an office they can do.
Who would ensure the compliance of this? Refund court में deposit होगा तो उसका consideration अलग है. It will not be the same. We have to figure it out. Dispose of in their course. हाँ बैंक अकाउंट डिटेल्स दीजिए. Exact दे दीजिएगा. 500 का है. कौन सा 500 है? हाँ वो कहाँ है वो एडवोकेट साहब जिनको ऑब्जेक्शन आइए फाइल किए थे आप है ना आप यू आर देयर आपने स्टैम्प पुटिंग किया उनको तो वकील साहब को ठीक से समझ नहीं थोड़ा सा उनको बताइए आपको समझ आ गया
डिफेक्ट पॉइंट ऑफ हुआ है डिग्री को देखते हुए हाँ और हम पार्टी बनाए हैं फर्स्ट अपील जो प्रीवियस फाइल हुआ है सुप्रीम कोर्ट से रिमांड हुआ था
डिग्री के अनुसार बनाना होगा तो आपको हम टाइम दे देते हैं ठीक है आइए को डिस्कस करते हैं
डिग्री के अनुसार ऑलरेडी पार्टी बना हुआ है खैर वो डिलीट करना होगा कुछ नहीं
आप इनके साथ बैठ के कर लेंगे दैट विल बी बेटर आप बता देंगे उनको ना ही विल गो टू यू एंड टेल देखिए आइए नंबर कौन सा है 11356 has been filed for ignoring the defect number 25 within bracket 3 in connection with defect number 25. However, the counsel for the appellant has submitted that there are certain mismatch which he shall rectify and the preemptive time may be extended. Considering the aforesaid submissions, the time for removal of defects in terms of order dated 3/7/2026 is extended till 3rd of September. Okay. IGA closed. Office is directed to place this case under appropriate heading on 9th of September. ये फ्रेंडली ही है ऑर्डर, लेकिन डिलीवरी नहीं होना चाहिए. ठीक है, आप बैठ के समझ के कर लेंगे.
Prohibition item 5, first April 3/8/2026.
This is for the admission.
For admission.
For admission. Plan for builder to sue was not mandated on the ground that the sale does not have the power.
Oh.
That is the cooperative society.
Cooperative Societies Act देखें.
Yes, sir.
Section 43.
48.
48.
Dispute.
The
business of the offer. If any dispute touching the business of the registered society arises among the members.
This is not business of the registered. Admit. Issue notice to the respondents through the concerned police station, for which the requisites be filed within a period of 1 week. Right. Let the records be called for from the concerned court. Let this order be communicated through fax. पुलिस स्टेशन से बोल दिया सेक्रेटरी वाले लोग जल्दी से नोटिस एक्सेप्ट नहीं कर.
Personal service. In addition.
दस्ती in addition.
There is an IA or status which they trying to alienate the property.
Who will alienate the property?
The respondent number one.
How will they alienate the property? Cooperative का property ऐसे alienation possible है
They
क्या?
are trying, that's why.
नहीं कुछ नहीं.
Also their construction is going on within the place. There are multiple shops there. They are getting the rent from the shops also there. And now,
एक second. The notice be issued in the first appeal as well as IE number 11076 of 2026. Close this case on 3rd of September. Awaiting service report and also for hearing on IE. If the parties appear, the case can be fixed for final disposal. Supplementary list पे डालना. ठीक है? आगे सारा मैटर में सब लोग आगे. Everybody is here?
I have to call.
Yes, call him because I have a meeting at around 4:35. So I was just wondering कि क्या करेंगे. नहीं करेंगे ना अभी करेंगे.
We got free earlier than I mean.
That's really good. Just worried about this. But एक करके आगे बताएंगे.
This is the like lordship permit to place certain parts of your lordship's order dated 28/11. Because
Order dated 28/11.
20. That will be order number 103.
103. Yes, please.
Lordship will only come to paragraph 15. Where it was.
Yes.
Paragraph 15 will be in page 13.
Yes, I'm there.
The prayer for adducing additional evidence has been opposed by stating that M forms are forged, fabricated, they were never issued. It was also asserted that the contents of the documents should also be proved in terms of section 61 and 64 of the Indian Evidence Act. and without complying with the said provisions, no document or its contents can be admissible or proved. And for the same, evidence of the oral evidence have to be adduced before the trial court with an opportunity to the opponent for objection and assert that the documents cannot be marked as exhibits. An objection was also raised in connection with the certified copy of the order of recommendation dated 8/11/2004, passed by the learned land reform deputy collector Dhanbad in this case number such. It was stated that the recommendation for cancellation is not relevant and also asserted that the same document was already available at the time of trial, but the same was not produced and it cannot be said that even after exercise of due diligence, the evidence was not within the knowledge of the plaintiffs. It has been asserted that documents cannot be termed as public documents within the meaning of Section 74 of the Indian Evidence Act, and there cannot be any presumption in terms of Section 78 of the Evidence Act. The respondent number 5 to 11, we are the respondent number 5 to 11, have also filed an objection to IA number such and such stating that documents sought to be adduced.
Respondent number 10 to 15 लिखा है.
10 to 15, I think. 10 to 15, we are 10 to 15. And the
So
documents,
you did decide, no? The
it was
direction
my
ऐसे तो
petition.
बहुत मुश्किल है. जहाँ जिसका पोजीशनिंग है वहीं पे रहिए. हाँ.
I thought it was my IA.
No. It's, you maintain your position. Yes.
The respondent number 10 to 15 have filed an objection to IA number 4184 of 2022 stating that documents sought to be adduced as additional documents through IA number such and such is forged and fabricated and the document do not come from the proper custody as mandated under the provisions related to the document. So these were the observations. Para 17. It has been asserted that the plaintiffs to prove the contents as well as genuineness of the documents which are yet to be done, the concerned respondent have prayed for granting permission to cross-examine the witnesses for the contents and genuineness of the documents. It has also been asserted that it is an admitted fact that only 3 remaining informs were filed in the trial court and therefore the learned trial court has based its judgment on the inconclusive evidence and that's for alone the judgment delivered by the trial court dated such and such is liable to be set aside. It was also asserted that verification of these informs were also necessary for proper adjudication of the case which falls within the domain of the trial court. And it was also asserted that an FIR was instituted, it was also asserted that the circle officer Bagmara had submitted an inquiry report to the deputy commissioner collector Dhanbad by letter number such and such dated such and such, wherein it has clearly stated that informs bearing serial number such and such were not issued from his office, and it was asserted that this means that to show that informs on record were forged, fabricated, and trial court delivered the judgment dated such and such on the forged and fabricated informs. It has also been stated that opening of Jamabandi itself was under a cloud and the Jamabandi was kept in abeyance. The documents annexed were required to be proved under section 76 to 90 of the Evidence Act and they are not public documents. And it has also been questioned that even before the trial court dated in the year 2008 that 3 informs produced and straight away marked exhibit, they were obtained from someone and not from the proper custody in 2008 and same method was sought to be followed in the appellate stage. So this was our submission. Now, Lakshmi, can you come to paragraph 32? First, we have stated that it is forged. Then we have stated in paragraph 32 Lakshmi, that there is mismatch otherwise also. It is apparent that when the informs have been filed, omissions to bring on record these documents at the stage of trial appears to be on account of oversight on the part of the conducting person or the power of attorney holder. Further, certified copy of the order dated such and such, passed in cancellation of Jamabandi case number such and such, and also certified copies of Jamabandi number such and such are closely linked with the informs that defendants have tried to state that there are mismatches between the informs of the plaintiffs and the certified copies of the Jamabandi number such and such. However, issues of informs is not in dispute. We do not say that these are the same informs which they seek to produce were issued. We say informs have been issued, but these are not the genuine. This your Lordship has observed, but I will show that the learned trial court has misinterpreted this line of your Lordship. Thereafter, has the Lordship marked this line? However, the issuance of informs is not in dispute. We did not say that the same inform. We have stated it is forged, and we did not admit that these are the same informs which has been issued. We said the informs have been issued.
There are certain mismatch. Inform has been issued, But the fact that informs were issued is not in dispute.
Informs were issued, but these were not the. We had therefore previous paragraph I showed that our specific contention was that informs which they seek to produce are forged documents. And Lordship also did not say that these are genuine documents. Lordship said that issuance of inform is not in dispute. Whether these are the genuine or which is genuine is for the trial court to see. Now Lordship will kindly come to para 35.
No, what was the direction to the trial court?
Yes. Lordship will kindly come to. Then Lordship para 35 onwards I am reading, it is the concluding portion.
Yes.
It may be noted that issuance of inform in the name of Srimati Ambika Bala and Rabindranath Pal in rent succession case number such and such respectively has been specifically pleaded in the plea. They are not yet, there has not been any denial in the written statement regarding issuance of these informs, but it has been contended that it was issued in collusion with the revenue authority.
This is the situation.
Yes. These informs are important piece of evidence to ascertain that after vesting of the intermediary interest on coming into force of the Bihar Land Reform Act 1950, who are the parties accepted by the state as tenant with respect to the suit land, and they got vested in the state or for the purpose certified copies of Jamandi number such and such are also relevant. Equally important are the connected proceedings of miscellaneous cancellation of Jamandi case number 5 of 2004-5, which are order dated 8/11/2004 was passed. There is substantial cause of admitting these documents into evidence. If these documents are not admitted on technical grounds, it will result in miscarriage of justice. The court has also considered the view that these documents are required by this court to enable to pronounce the judgment with clarity regarding the claim of the respective parties. Since the arguments have been advanced with regard to genuineness and authenticity of additional evidence in the file is sent back. Let me kindly mark this sentence. Since the arguments have been advanced with regard to genuineness and authenticity of the additional evidence, the file is sent back to the court below to take additional evidence on the aforesaid documents, and after completion of recording of the additional evidence, send it back to the court. An opportunity of rebuttal. Lordship kindly mark this part also. An opportunity of rebuttal is also given to the other side by the court. While taking additional evidence, the court shall consider the genuineness and authenticity of the additional evidence, including as to whether the contents thereof has been proved by the party relying thereon, and thereafter written. Lordship has been careful in using each and every word. The contents thereof has been proved by the party relying thereon, and thereafter to return the evidence to this court together with its finding thereon with reasons. The learned trial court shall afford an opportunity to the other party to adduce evidence in rebuttal, but confined to the aspects covered not the aforesaid additional evidences. Means if they lead the evidence with respect to informs, we should be given an opportunity to rebut with respect to informs only, nothing else.
Informs and one order also.
Yes, no, I'm just giving an example.
Yes.
Whatever evidence they need, our opportunity is confined to the rebuttal of that.
Rebuttal, cross-examination, everything.
Yes.
So what did the
Yes. Now your lordship will kindly come to the
court do?
yes. Just
Where is the order of the court?
so there are 2-3 orders which we have challenged. If your lordship first
So IA number?
IA number 6851. 6833 first.
6833.
Double
इससे IA निकाल के देंगे. Say 33 or 26.
2026, yes. So when the matter was remanded back, we prayed for 2 things. One is also that in view of the remand, the court will frame a specific issue so that both the parties are confined to that issue. Yes, I agree, Lordship. That was our first prayer. And secondly, we said that let all the informs, the custodian of the original documents is the circle officer. So let the records be called for from the office of the circle officer to verify it, or let an officer is called. So both the petitions
who wanted to lead this evidence? You wanted to lead this evidence?
Plaintiff wanted the respondent. Datta,
I don't remember. Datta's wanted to lead this evidence.
Yes.
Okay.
Pauls wanted to lead this evidence.
Pauls are the appellants.
They are the plaintiffs in before the court, you know.
You wanted to lead this
Yes,
evidence.
No, we have already produced M forms and they filed a petition to summon the circle officer.
They wanted
Okay,
to.
you filed the original whatever you had before
Filed
the
and I
authority.
proved it by examining the original plaintiff himself.
Okay.
And thereafter, when
So it was from proper custody.
yes, that was the truth. That was true. So this was found to be correct by the trial court, and therefore trial court has accepted that it is genuine and it has been brought from the proper custody. Now they file a petition to summon the circle officer. We filed a reply. That reply is very important. We did not say that no circle officer should not be summoned, but we said very categorically that if the circle officer, his knowledge cannot be, his knowledge has to be based on the records of the case. And therefore, if he is summoned, then all the records, he must come to the court with all the records. And he cannot depose only on the basis of an overall submission. This was our stand.
Let him complete.
Yes, only. I apologize. Now, Your Lordship, 6833 and 6852 are connected, same matter, therefore they may be heard.
6852 is what?
It is again the final order where the trial court has said that it is genuine.
So one by one,
Therefore, I said that these two are connected. This is only
There are two IAs. IA
Three
number
IAs.
6833 of 2026.
three IAs.
One is IA number
6833.
6833 is what he is placing.
I'm placing this.
Yes. And other
And
IA?
the connected IA would be 6852.
6852.
This also is
On
related to
2026. Who has filed this IA?
So we have filed 3 IAs.
Okay.
So I'm
First,
placing
we are just taking up these two IAs only.
That's not sure.
What is the third IA?
Not sure. I'm giving the present IA, thereafter 6851 and
Why have you
68.
filed a separate IA to challenge that one?
Just separate prayers for separate. So otherwise it would have, all the issues would have been jumbled up together.
So in this IA, first 6833
I have challenged the order dated 18/2/2026.
against the interim order.
Interim order.
What is that interim order?
Yes,
Let
I'm
us
reading
read that
out.
order.
Yes, page 30, Your Lordship.
Yes.
First part, what is current view, Your Lordships? I just reading it. Plaintiff number 1A to E and 234. Respondent number 1 to 8 and respondent number 6 to 18, 16 to 18. Defendant number 5 to 10. Performer respondent number 10 to 15 and respondent number 19 that finds attendance. Case record is fixed for order. I have heard the parties. It appears that 3 separate petitions have been filed by the parties, which are thus: 2 separate petitions dated 27/1/26 and 28/1/26 by the defendant number 6 and 7, performer respondent number 11 and 12, under order 14 rule 1 and order 41 rule 25 to 27, read with 151 CPC for framing issues after remand and permitting the parties to lead evidence. Petition dated 27/1/26 filed by defendant number 5 to 10, orders under order 16 rule 1 and 2 of CPC for issuing summons to the circle officer Bagmara for proving M forms. Apparently, the above defendants are praying to this court for passing an order with regard to framing of issues for consideration and summon to the circle officer Bagmara under order 16 rule 1 of CPC. Coming to the prayer of framing of issues for consideration as separately prayed by defendant number 6 by petition dated 27/1/2026 and defendant number 7 by petition dated 28/1/2026, I find that during hearing, learned counsel appearing for the defendants argued that this court failed to appreciate the actual spirit of the order of the Honorable Court in first appeal number such and such, whereby the Honorable Court directed this court to record additional evidence and consider the authenticity of the evidence for which the court needs to frame an issue on this specific point, but without doing so, this court proceeded to record the evidence due to which ongoing proceeding becomes inconclusive. He submitted the order 41 rule 25 to 27 clearly mandates framing of issues, and in light of the above provisions, they framing of specific issue. He submitted that both the petitions filed by the defendants may be allowed and they may be permitted to lead evidence. Learned counsel appearing for the plaintiff respondent number 1 to 8 and 16 to 18 vehemently observed. Also, they are represented by opposed the defendant and submitted that Honorable Court by order dated 28/11/2025 passed in FA number 77 did not remand the matter, so there is no question of framing issues under Order 41 to 25 to 27 of CPC as pleaded by the defendants. Rather, the Honorable Court sent back this matter to this court for limited purpose of taking evidence under Order 41 to 27 by specifically framing a point directing that this court to consider the genuineness and authenticity of additional evidence, including as to whether the contents thereof has been proved by the parties relying thereon as per Rule 29 of Order 41 of the CPC, and as such, no need to be framed as prayed by the defendants. He submitted that the same prayer was made by the defendant performer respondent number.
Are you aggrieved by this portion of the order? Additional issues to be framed. Did I direct for framing of additional
This
issues?
part I am leaving. I am coming to the next.
So you forget it.
Now
So this, so far as grievance number 1 is concerned, you have no grievance.
Leave it to this honorable court.
No, you have to. If you want, I will deal with it. You can't just leave it to the court. Either you will say that you want to press it.
And I am not pressing it as a person. That will not prejudice us.
No, there is no question of any prejudice. Yes. But being a counsel, there was no question of framing any issue.
Issues is binding the parties within the parameter of the
What is this? No. For additional evidence.
Because ultimately the court gave a finding. But had it been a case that only recording the additional evidence and forwarding it to this.
No. I had asked him to give a finding.
So therefore we said that
there was a direction to give a finding also.
Yes, therefore
because that finding will be then considered before this court.
Yes. So therefore we said that for recording a finding there may be an issue, but lordship for the present leave it, that will not cause prejudice to us. Now coming to the prayer of defendant number 5 to 10. Order 16 Rule 1 2 of CPC summoning Circle Officer Bagmara to prove M forms. I find that it is submitted by the defendant that Circle Officer Bagmara issued the M forms, and it is settled proposition of law that the person who has issued or executed the M forms is the competent person to prove the same, and the Honorable Court also directed the additional evidence by proving the M forms and its corresponding Jamabandis to be proved in this court, and as the Circle Officer Bagmara issued these documents, which are incorporated in the examination chief of Manipatra Pal. As such, the examination of Circle Officer Bagmara is necessary. He submitted that the Honorable High Court had also directed this court to consider the genuineness and authenticity of the informs, and concerned Circle Officer is the best person to depose regarding the genuineness of this document. He submitted that plaintiff also filed a reply dated 17 to 2026, whereby para 8 they had stated they are not against summoning of the Circle Officer Bagmara, but as he does not have personal knowledge in this matter as such, he may be summoned to come with all the relevant records. So they also did not object to it pertaining to the M forms mentioned in Schedule A in their reply. He submitted that as the contesting parties also showed that there are no objection to the summoning of Circle Officer, as such the prayer for issuance of summons to the Circle Officer for evidence may be allowed. It appears by an order dated 28/11/2025, the Honorable High Court passed an order in FA number 43 of 12. As the matter has been sent back to the court for recording additional evidence with the direction, this court has considered the genuineness and authenticity of additional evidence, including as to whether the content thereof has been proved by the parties. According to the plaintiff, respondent number 1 to 9 by witness Manipatra Paul, respondent number 9 proved 2 M forms issued in rent fixation case number such and such exhibit 10D and 10D respectively. At present, the defendant number 10 to 15 came up with a prayer to prove M forms which were already proved by the plaintiffs as per the direction of the Honorable High Court in IA number such and such. It is clear from the order of the Honorable High Court that prayer of the plaintiff respondent 1 to 9 in IA number such and such was allowed with regard to leading additional evidence of 2 M forms, and there is no such direction to defendants in this regard, and as such, the prayer to summon the Circle Officer to prove M forms which has already stood proved by the plaintiff as per the direction of the court is not sustainable.
Only 2 forms were to be considered, not all. Because they had produced 2 M forms before this court for additional evidence.
Yes, these 2 M forms were
only 2 M forms were to be considered, not all of them.
Yes.
So you filed an application that all the M forms were.
All the M forms filed by the plaintiffs in the additional evidence.
They only filed 2 M forms.
Always these 2. If it is 2, then it is 2 only.
Yes.
But also that has to be proved. We said that the Honorable Learned Court below was of the view that no, that cannot be done. The plaintiffs have proved it and this Honorable Court accepted it therefore. The defendants have tried to argue to this court that under obligation to decide genuineness, and authenticity of the informs, then the concerned circle officer is the best person to depose regarding the same. The learned counsel appearing for the plaintiff strongly opposed this prayer and submitted that genuineness and authenticity of the document should be decided on the basis of pleadings and evidences. And parties are prohibited from leading evidence beyond the pleadings of this case. The defendant did not challenge the issuance of informs claim, which is evident from paragraph 32 and 35 of the order of the Honorable High Court, and as such, prayer of the defendant is beyond their pleadings too. Apart from the defendants, respondent number 10 to 15 in IA number such as try to bring additional evidence by producing corresponding jamabandis issued in the name of the plaintiff to show the mismatch of increase of the efforts at jamabandis and informs, and further the prayer of the defendant with regard to forgery of informs IA number such and such and IA number such and such filed by defendants, which is in the same line, stood rejected by the Honorable Court as no ground found to be made out to allow the additional evidence, as nothing concrete has been crystallized with respect to the allegations made therein. That stage, Lordship rejected it on the ground because those informs were not exhibited till that date. The learned court
No,
will say that
the entire controversy for the additional evidence was only in connection with two informs and nothing more.
nothing more. Two informs, we say it is forged. Lordship, we also filed an IA before this court as a counsel, I may Lordship say, and we wanted to bring on record the inquiry report of the circle officer saying that these are forged. Lordship said that nothing concrete has happened, nothing concrete has been crystallized till now. Therefore, Lordship disallowed those IAs. But at the same time, Lordship gave me an opportunity to rebut the genuineness of that affidavit. That your Lordship has seen in the order, Lordship gave us the opportunity to rebut the genuineness of the documents filed. And Lordship directed the court below to examine the genuineness. Party to a dispute who is producing a document will always vouch that it is genuine. But court was directed, otherwise Lordship would have taken it as an evidence before in the appellate stage by your Lordship's only. Since now next Lordship, since the issuance of inform is not in dispute, Lordship, this is what your Lordship I read from.
The issuance of inform is not in dispute, but whether they were the same
Same,
informs
yes. This
is
learned
something
court
which,
was cited.
which was required to
Yes.
be considered, whether those were the very
Very
informs
informs.
which were issued.
Yes, Lordship. And the learned court below got swayed by that one line that Lordship said it is not in dispute, then how can I challenge the genuineness? Since the issuance of informs is not in dispute, and further the allegation of forgery as projected by the defendant stood rejected. Lordship rejected it as that by that time nothing has crystallized. Those informs were not part of record. So rejected by the Honorable Court, and moreover the petition of defendant did not show
So
any reason.
you wanted the circle officer to come and depose only in connection with
The
these two
genuineness of the
informs.
additional evidence, nothing more.
Or they only produced these two informs.
Yes.
And they wanted the circle officer to come with the corresponding records.
Yes, nobody, that would have been, everything would have been clear. He would have come with the record and would have matched and said to the court, yes, this is part of my record or this is missing in my record. Only two things he could have said. And Lordship may kindly see, Lordship, how the informs have to be maintained.
Complete reading of this.
Yes. The defendants also tried to argue that plaintiff showed no objection for summoning the circle officer, but this stand of the defendant is of not helpful to them, as even if the plaintiff consented for summoning of the circle officer with a direction to produce, the documents as mentioned is annexed in schedule oblique list with reply dated 17/20/2006 containing reference of several documents as original ledger, files, control register of entire informs, original report dated such and such of the circle officer, original letter number such and such dated such and such of LRDC Dhanbad, and letter number such and such of the revenue staff. Then also, accepting the prayer of the plaintiff will lead to allow them to bring on record further other evidence as per the list oblique schedule, which has not been directed by the Honorable Court. Lordship kept everything open for rebuttal, we can lead any evidence. And adopting the said course of procedure will certainly amount to travelling beyond the direction and boundaries of the fixed by the Honorable Court, which is not sustainable. So it is just like Lordship tying a person's hand and limbs and saying that now you swim, I am giving you an opportunity to swim. And Lordship, before going further, if you Lordship just see the provisions of claim form, how it is to be maintained. Lordship, Rule 7I of the Bihar Land Reform Rules 1951. Just it is a very small provision.
They are land reforms.
Question, additional.
Which page is that?
It should be in my book. It is page 96. Just after the act, we have land reform rules and there.
Fixation of fair and
Which
form
seven-
M, preparation of rent roll.
Yes, 7I.
Hmm.
Preparation of rent roll form M. The fair rent or ground rent determined by these rules in each proceeding together with requisite particulars shall be entered in form M roll, rent roll under the signature of collector, and such rent roll shall form part of the case record to which it relates. So it is a part of the official record. If the record comes and it is matched with the copy which the plaintiff is, because that will continue to be the record, your lordship of this. So entire controversy will come to an end. If it is genuine, we lose.
What do you say, Mr. You had no objection in the circle
No,
officer.
no, because what was happening that he was
You
he had
see,
already issued
let
a
us
letter.
capture what he wants to say.
Yes.
It is one thing to say that the issuance of M form is not in dispute. And it is another thing to say that what is being produced is the very same M form which has been issued. It is not one and the same.
But here
सर्टिफाइड कॉपी इशू हुआ ठीक है,
ठीक है,
लेकिन ये वही सर्टिफाइड कॉपी है तो आपको ओरिजिनल
I
रिकॉर्ड से
get
चेक
your
करना
point. I have to answer it directly. Now, my submission would be because I had already stated, therefore, that we had consented that firstly we said that he is not required to be summoned, but if he is summoned, then he cannot depose on the basis
आइसोलेटेड
of
नहीं
his
हो सकता.
personal knowledge. He
Fair
has to,
enough.
whatever he deposes, it has to be on the basis of the record.
Record. Every statement has to be backed by the record.
Why it was so? Because he had
वो पहले कब हुआ
नहीं
वो
नहीं
notes.
ये एक लेटर इशू कर दिए जो कि बोल रहे हैं कि मेरे यहाँ से नहीं इशू
हाँ.
blank letter which is this particular letter is absolutely against the other exhibit which has been marked. If that exhibit is seen, your lordship will kindly see that exhibit. That is a report of the LRDC.
We are not going into that.
I am answering to the query itself directly. Now the LRDC very clearly mentions all these inputs and all the khatas which are mentioned in the input. So once he says,
Then you will confront him with that particular document.
Yes, yes.
Naturally, because there is a order passed that these end forms have been issued which contains these particular
and it is there.
records.
It is there. This was the reason that we had said that if he comes, then he must come with the entire.
That's right.
He could not have deposed only on the basis of his personal. So this was, and LRDC mentions that circle officer that has been marked as executive. That is seen.
I've seen that. इतना सुने हैं आपको 15 दिन 20 दिन 25 दिन कितना
उसमें बहुत क्लियरली वो बोल रहे हैं कि सारा ये एम फॉर्म है और सारा एम फॉर्म इशू किया गया है
प्रॉपर्टी भी है
और सर्कल ऑफिसर के द्वारा इशू किया गया ये लिख रहे हैं एंड सर्कल ऑफिसर सेज दैट आई हैव he is clearly denying all those documents. So can he do
the
so?
M form has been issued under whose signature?
Under
whose signature?
the circle officer.
Circle officer. M form was issued when?
62-63.
62.
And second, therefore,
तो उस सारे M forms एक साथ issue हुए होंगे.
हाँ एक साथ.
और आपके जो M forms जो already admitted है और record पर है.
हाँ.
उसका signature और इसका signature तो same होगा.
सब एक साथ है. सब एक साथ है. Continuous. और सारा इन्फॉर्म्स
देखिए ऐसा है ना कि अब हम इसको वापस रिमांड नहीं करेंगे.
नहीं,
जितना एविडेंस प्रोड्यूस करना है यही पे प्रोड्यूस करिए. अब हम इसको वापस रिमांड नहीं करेंगे. I can take additional evidence.
100%.
I will take it.
बस वही हम
आपको जो करना है सर्कल ऑफिसर को यही टुकड़ा करें.
हाँ यही हम यही बोल रहे हैं.
क्यों? Because when I will see the documents,
नहीं.
it will be more clear to me.
Lordship can also put a question to the.
हाँ I agree to that.
ये नहीं होगा क्योंकि ये केस जो है हम ये वहाँ ट्रायल कोर्ट के फाइंडिंग्स पर या वहाँ पर जो एविडेंस रिकॉर्ड होगा
एकदम,
उस पर
I-
हम नहीं डिसाइड
हम
कर
नहीं
that
बोल रहे हैं.
that I can
I
see
say that your lordship may call him.
and much will
and-
depend upon that.
Yes, I say another submission of mine. Now they themselves produce registered that mentions that it has been opened on the basis of rent assessment case. Where is that rent assessment case?
He has to produce all the records.
He has to at least produce that. He cannot say that I have not issued, because LRDC, he submits his report before LRDC and he mentioned that I have सत्यापित किया है सारे को और प्लॉट को मैं सारा
बस वो आ जाएगा तो सारा रिकॉर्ड आ जाएगा तो
हाँ, ठीक है,
पानी
ठीक है,
का पानी
हम
हो जाएगा
एकदम-
फिर क्या है?
कोई ये नहीं.
Our efforts will come. Either it is in his favor
मेरा
or my favor.
मेरा एक ही रिक्वेस्ट है, मेरा एक ही प्रेयर है कि सारा जो मोजा रंगुनी का जितना इन्फॉर्म का जो रजिस्टर है, he must come with those. He cannot just say that
कितना होगा वॉल्यूम?
वॉल्यूम्स होगा.
एक महीने में बहुत
कम
ज्यादा
से
नहीं
कम,
होगा.
क्योंकि वो बोल रहे हैं नहीं, अब ये नहीं.
भाई एक मौजा का एक ही रजिस्टर होगा ना?
एक ही register होना चाहिए.
भाई जो इशू हुआ होगा उसका एक ही
एक ही
रजिस्टर
register दो
होगा.
volume होगा या उससे ज्यादा नहीं हो सकता.
इस-
पता नहीं होगा.
ये जो रेंट असेसमेंट केस का जो भी ये जो रेंट असेसमेंट केस जो रजिस्टर 2 में मेंशन है, इसका जो भी आपका रजिस्टर 2 का जो एम फॉर्म है वो ले आएंगे, क्योंकि इश्यूएंस ऑफ एम फॉर्म इज नॉट इन डिस्प्यूट. सो व्हाट इज दैट एम फॉर्म which is there recorded in the
या तो वो लेकर आएंगे जो ओरिजिनल इशू हुआ था इन्फॉर्म,
हाँ,
या तो वो लेके
ठीक-
आएंगे
ठीक
पैरेलल
है,
इन्फॉर्म
ठीक
कि
है.
भाई ये नहीं ये इशू,
हाँ, exactly.
because issuance is not in
Not
dispute,
in
हाँ.
yes.
right? Either he will bring those informs which were actually issued,
Yes.
right?
Yes, yes.
Correct?
ठीक है, हम
जो इशू हुआ होगा या तो वो लेके आएंगे कि भाई ये इशू हुआ था, दिस इज अ फोर्स्ड
Yes, and form M roll जो है, जो statutory document है, form M rent roll, ये लेके आएंगे. दोनों से मैच हो जाएगा.
कौन लेके आएंगे?
Circle officer. He
नहीं,
is the custodian.
see, the only thing the circle officers can do is either produce the informs which according to him is genuine,
Yes.
वो लेके आएंगे,
Yes.
और उसका वो corresponding record लेके आएंगे.
Corresponding record वही हो गया lordships. Form M rent roll. जो rent roll में entry रहेगा, अगर इनका नाम से फॉर्म है, तो rent roll में भी वही लिखा हुआ रहेगा. मान लीजिए rent roll में मेरा नाम लिखा हुआ
अगर
है.
मान लीजिए उनके पास, एक सेकंड, आप तो कोई इन्फॉर्म नहीं प्रोड्यूस कर रहे हैं ना?
नहीं.
आपका तो कोई इन्फॉर्म नहीं है.
नहीं, इनका था लेकिन वो कैंसिल हो गया भाई.
हाँ, वो कैंसिल हो गया, इसीलिए वो तो कहानी
सारा
खत्म है.
सेट असाइड.
अब इनके पास जो भी इन्फॉर्म है, राइट, ईदर the circle officer will produce the original inform
Yes, yes.
which he says that these are the informs and these are not them.
Yes, and
We will ask him to produce those informs. अब करना क्या है?
हाँ,
वही तो बोल रहा हूँ.
उसके अलावा कोई डॉक्यूमेंट नहीं.
ये एक लाइन हो.
नहीं, inform के साथ lordships.
क्यों चाहिए हमको?
जैसे register
Maybe
deed, I'm
either-
just explaining.
नहीं,
अच्छा,
क्या
register
चाहिए?
deed जैसे
Just a
होता है.
moment, Mr. Das. The fact that informs were issued is not in dispute, so he has to produce the informs which he says were actually issued. उसके पास भी तो inform होगा ना?
होना चाहिए.
होना चाहिए.
दो
He will produce
चीज
it.
से corroborate होता है lordship. जैसे register deed भी होता है. तो
नहीं, हम लोग इसको वाइड ओपन नहीं
नहीं,
करेंगे.
वाइड ओपन नहीं, हम बता रहे हैं इसी का रिलेट में. लॉर्डशिप जो इन्फॉर्म इशू होता है, उसके इन्फॉर्म रूल मेंटेन होता है. मान लीजिए कोई इन्फॉर्म ऐसे ले आए जो फटा हुआ है, नहीं पता चल रहा, तो उसका corresponding इन्फॉर्म
नहीं, हमको देखना है ना, क्यों देखना है हमको?
मेरा एक सबमिशन.
Why should I see that? Either he will bring the informs which are actually issued.
Yes, and
He
inform
can say that this is not the certified copy issued,
Yes.
right? Then he will bring the certified, the
Yes.
original.
और
He
ये
has to
therefore
bring
is
the
it-
original.
entire record
Original
is
अगर
inform.
कोई रिकॉर्ड का जरूरत नहीं. जो inform है वो वही लेकर आए.
हाँ, ठीक है. inform
बस बात
ये
खत्म.
तो बात है.
वो 2 डॉक्यूमेंट लेकर
हाँ,
आएंगे
एकदम,
inform,
एकदम,
और इसके अलावा
मेरा-
हमको यहाँ पे कोई
हम
फिशिंग इंक्वायरी
एकदम
थोड़ी करना है.
उसमें ये कर रहे हैं, सिर्फ the basis of which the register 2 he has mentioned, he has opened register 2, those informs he must put. On the basis of which he has opened.
रजिस्टर्ड 2 में मेंशन है ना,
हाँ,
inform
हाँ,
number
हाँ,
this
लिखा हुआ है,
this
लिखा
इससे एक ही चीज किया जाए. Entire inform with respect to रंगूनी मौजा प्रोड्यूस करना, उसमें इनका वाला मैच हो जाएगा.
नहीं. एंटायर हमको क्यों
वैसे
open
register
करना?
2 में अगर forged inform का entry ये हुआ है.
Just a moment, Mr. Das. If his inform is forged,
Yes.
we should get the original one from the circle office.
Yes, this is what I am saying.
बस इतना ही.
My
I will
director
just
is
ask.
improving
I
the
will
method.
just ask the circle officer to produce the M form which contains this number.
This
बस
number,
आप खत्म.
this
Because
plots.
issuance of this M form
Yes.
with this number is not in dispute.
This number is also disputed.
No.
नहीं,
Where
ये-
have we
ये
where
बताओ.
have we disputed this
Yeah,
number?
Now he is
No, no, no. That is not
Lakshmi
in
only
dispute.
one thing. Lakshmi only say, Lakshmi, one thing which cannot be changed by any party is the plot number and the merger. Relevant M forms with respect to this plot number
नहीं
and merger.
नहीं.
ये-
अगर मान लीजिए वो बोलेंगे कि इसका ये M form issue नहीं हुआ था,
हाँ.
वो लेकर आएंगे कौन सा M form
हाँ,
issue हुआ
उसीलिए
था.
तो बोल रहे हैं.
और अगर उसमें भी अगर मान लीजिए कोई नंबर मिसमैच करेगा या कुछ और डॉक्यूमेंट मिसमैच करेगा, then we may still call upon him to produce further records.
As a lot.
We just we do not. ये कोई वो तो नहीं है कि कहानी खत्म ही नहीं होगा. ऐसा नहीं है यार. कोर्ट में कहानी
हम
खत्म
चाहते
हो
हैं कि एक ही बार आया कहानी खत्म हो जाए. Because we have also worked on this for a long time, we also want that it comes to an end.
Yes.
If he is summoned, then I'll confront him with a certified copy of his own report.
That
Which is
opportunity
mentioned.
both of us will get.
He
that.
had-
नहीं, you will have an opportunity.
हाँ,
आपसे बेहतर
ठीक
आप
है,
लोग दोनों के
ठीक
बेहतर
है,
वहाँ
वो-
पे कोई थोड़ी
वो
क्रॉस
सर-
कर लेगा आप लोग से ज्यादा.
उन्हीं का रिपोर्ट है जो उस समय दिए थे, जो LRDC का रिपोर्ट में लिखा हुआ है,
yes.
उनको हम कन्फ्रंट करेंगे उसको.
जी, जी.
और देखिए दो M फॉर्म जो है जो
हाँ.
ऑलरेडी रिकॉर्ड पर है, जस्ट आई एम जस्ट इंडिकेटिंग, जो ऑलरेडी रिकॉर्ड पर है अनडिस्प्यूटेड.
हाँ.
राइट.
तीन अनडिस्प्यूटेड
तीन
है,
अनडिस्प्यूटेड है.
हाँ.
तो तीन अनडिस्प्यूटेड जो सर्कल ऑफिसर इशू किया है, सेम ये भी इशू किया है. So there will be no mismatch in the
कुछ नहीं,
in the
एकदम नहीं होगा, एकदम
in the
नहीं
signature or
होगा.
anything.
एक आध दो प्लॉट कहीं से वो नंबरिंग में ये होगा, अदरवाइज कोई सारा खाता का मैच है.
अगर
सारा
genuine है तो
खाता
कभी नहीं
मैच
होना
है.
चाहिए.
सारा खाता मैच है. और जो डिप्टी कमिश्नर सारा रिपोर्ट में एक बात आया है कि प्लॉट नंबर 631 632 जो मेरा पोजीशन में नहीं है, सैरात है, उसको भी मेरा जमाबंदी है, उसको हटा दिया जाए. एंड दैट हैज बीन एक्टेड अपॉन एंड दैट हैज बीन रिमूव्ड एंड दिस इज मेंशन्ड इन रजिस्टर.
और ये जो M फॉर्म है ना वो बिल्कुल पढ़ा नहीं जाता.
हाँ
ठीक है. इसीलिए प्लीज आप लोग टाइप कॉपी फाइल किए थे शायद उसको. आई डोंट
किए थे.
रिमेम्बर.
किए थे.
भाई आप लोग आपस में बैठ के समझ के एक मतलब कॉमन टाइप कॉपी
जी,
फाइल.
जी, जी.
तो देयर शुड नॉट बी एनी
Yes,
डिस्प्यूट.
we'll exchange it within ourselves and thereafter.
तो ये ऑर्डर किस तरह से ड्रॉ करना है? विल आस्क द सर्कल ऑफिसर. अभी असल में मीटिंग है एक.
नहीं ठीक है. तो देन
We'll draw an order to this effect.
Yes, modify that improved order and also will say that instead of remanding back, Lakshmi will record the evidence here.
And I will ask the circle officer to produce the original M forms.
Yes.
Initially सिर्फ इतना ही आएगा.
हाँ ठीक है. हम कभी इमीडिएटली कर.
Whatever be the original M forms. अच्छा उसका दो कॉपी होता होगा. एक तो पार्टी को दे दिया
इसी के
जाता
लिए
होगा.
उस समय जमींदार को ही चीज दिया जाता था. एक कॉपी इसको दिया जाता था, एक कॉपी वहाँ रह जाता.
वहाँ रहेगा तो वो लेकर आएगा ना.
हाँ.
When he says that this is not the genuine, he has to simultaneously disclose which is the genuine.
हाँ.
He cannot have it like
इसीलिए
this.
तो वही बोला कि M-form रोल जो है उसी का आधा इनके पास रहना चाहिए, आधा M-form रोल है.
आधा
रोल
नहीं
नहीं,
होगा,
मैं
वो
खाली
copy.
M form बोलेंगे. अब M form रोल में पता नहीं कौन सा रजिस्टर वो देख.
लैंग्वेज
नहीं rent roll is the M form. That
स्टैट्यूट
was
में जो लैंग्वेज यूज्ड है वही हम बोल रहे हैं. And it is also mentioned that it should continue to become the part
तो
of
इसका
it.
ऑर्डर कल ड्रॉ कर लेंगे आप लोग. आ
हाँ कल
जाएंगे.
बेटर है.
कल बेहतर
सामने
रहेगा.
हाँ.
कल इसको सामने में आप लोग के ड्रॉ
हाँ.
करेंगे.
Tomorrow is it possible at 10:30?
कल तो फर्स्ट हाफ तो अच्छा कल तो एसेट डील अलग से है क्या? सिंगल लिस्ट है ना. ओके विल डू इट एट 10.
Yes, sir.
विल डू इट एट 10.
Item number 10 जो इंजीनियरिंग हो रहा है. Item number 10 से
आइटम नंबर 10 का एंट्री मॉडल एक्सटेंड करना.
17 जून के बाद नोटिस
आइटम नंबर 10 का ना एंट्री मॉडल एक्सटेंड कर दीजिए. द मैटर कुड नॉट बी टेकन अप. द एंट्री मॉडल passed earlier is extended till the next date. अभी जो डेट पड़ेगा उसके अनुसार. Other side has appeared, Mr. Sandhu?
Yes, Mrs.
Who is there?
Majumdar was appearing. Notice
You are
was
there?
incomplete. Mrs. Majumdar.
The parties are present. You are representing Mrs. Majumdar. What's your name? I have never seen you.
Aman, I am new. That's why Aman.
Okay, that's good. Which college from?
Studied from State University. I went abroad to study. Practiced there.
That's good. Good to see you here.
Thanks.
We'll have many opportunities here. Right? ठीक है।
Serial number 3 is for final disclosure. I'm only saying it may be taken because execution proceeding is going on, and the matter relates to handing over the management of a school to the respondents. I was only saying maybe kept on any.
It will come next week.
In
It will
supplementary versions. Yes. Because it is not being taken up for last 2 days.
Who is for that? Sir?
I will inform you. He was just here.
Next Thursday. In supplementary list. उनका appearance भी दे देंगे. कहाँ है वो? बुला के appearance दे देंगे. Who is the council? नाम बताइए.
Mr. Vishal Kumar.
अच्छा, he was here only.
Yes, sir.
Item 7 minus only 10 days delays there.
अब थोड़ा सा मीटिंग है, देखिए हम जाते जाते नहीं होते. Otherwise हम 5 बजे तक भी बैठे.
From the list leadership.
अरे भाई, हमारा human right नहीं है. I don't have an audience.